origins and historical context of data protection law. Rationale for data protection. Data protection laws are vital to safeguard individuals' fundamental rights and freedoms, particularly the right to privacy. In the digital era, personal data has become an increasingly valuable asset, with businesses and organizations relying heavily on its collection, processing, and use. This trend has led to various challenges, including identity theft, data breaches, and unauthorized use of personal information. As a result, comprehensive data protection laws are needed to ensure responsible handling of data and to protect individuals from potential harm. Human rights laws. Data protection is closely tied to broader human rights laws. The European Convention on Human Rights, ECHR, established the right to privacy in Article 8, emphasizing the importance of protecting private life, family life, home and communications. This was a key development in the context of European data protection law, laying the foundation for future legislation. The Charter of Fundamental Rights of the European Union, CFRIU, also enshrines the right to data protection in Article 8, further emphasizing its importance and solidifying its place in the European legal framework. Early laws and regulations, the OECD Guidelines and the Council of Europe. The 1980 OECD Guidelines on the Protection of Privacy and Transborder Flows of Personal Data were among the first international efforts to harmonize data protection. These guidelines aim to create a framework for the responsible handling of personal data in a global economy, outlining principles on data collection and use. The Council of Europe's Convention 108, established in 1981, followed, creating a legally binding framework for member states to protect personal data. Convention 108, this treaty set out comprehensive data protection principles, applying to the automatic processing of personal data. It was open to both members and non-members of the Council of Europe, laying the groundwork for future harmonization efforts. Convention 108 provided a baseline for national laws, establishing fundamental rights for data subjects and responsibilities for those handling personal data. The need for a harmonized European approach, the rapid growth of digital technologies and cross-border data flows necessitated a unified approach to data protection. Divergent national laws created inconsistencies and barriers to free trade within Europe, prompting the need for harmonization. A harmonized approach aimed to protect individuals' rights while facilitating business activities across the continent. The EU's Data Protection Directive, 1995, was a significant step in this direction, requiring member states to transpose its provisions into their national laws. The Treaty of Lisbon, effective from 2009, integrated the CFREU into European law, giving it binding legal force. This move reinforced the need for a unified data protection framework across the EU, paving the way for the General Data Protection Regulation, GDPR. The Treaty of Lisbon also established a stronger foundation for fundamental rights, ensuring consistency in data protection legislation across Europe. Convention 108+. In 2018, Convention 108+ was introduced to modernize and strengthen Convention 108. This version aimed to align its provisions with the GDPR, further harmonizing data protection standards across Europe and beyond. Convention 108+ addresses modern challenges, such as technological advancements and global data flows, ensuring that data protection laws remain relevant and effective. Brexit. The United Kingdom's departure from the European Union, Brexit, introduced complexities to data protection laws. The UK implemented its own data protection regime, largely based on the GDPR, to maintain adequacy decisions for data transfers and ensure continued cooperation with European counterparts. The UK's Data Protection Act 2018 incorporates the GDPR's principles, but its divergence from EU law over time may pose challenges for cross-border data flows. Summary: this historical journey highlights the evolution and importance of data protection in Europe. Data protection laws have developed to safeguard individual rights, balancing privacy and free trade while accommodating technological advancements. The harmonized approach to data protection is a crucial component of modern European law, addressing both the rights of individuals and the needs of businesses and organizations.